welcome to Bloomberg Quint. You're watching the fine print. With a debt of over 94,000 crore rupees and banks, NBFCs, mutual funds, insurance companies, pension funds as its creditors, the 6-member board of IL&FS will need a magic wand to make all of them happy. Anticipating that this outcome may not be possible and the IL&FS problem may not be ending in a fairy tale, the board has asked the National Company Law Tribunal for a moratorium until the final resolution is achieved. The board presented the progress report and way forward to the NCLT this week, in which it has pointed out that the creditor profile of the IL&FS group is spread across different categories and verticals. Individual creditors may have access to cash trapped in escrow accounts, which may lead to preferential payments, including by way of unauthorized set-offs. Over 130 creditors have issued notices to IL&FS group entities, and individual creditor action is unlikely to realize any value for creditors and will make an orderly resolution impossible. And so, it has requested the NCLT to extend the moratorium so that no legal action can be taken by any of these creditors against IL&FS or its 346 group entities. So, is that a fair ask? And more importantly, does the law allow for it? And how should the board navigate the debt maze and minimize risk of litigation once the moratorium subsides? To answer that, I have with me Fereshte Sethna of DMD Advocates and Pratibha Jain of Nishith Desai Associates. Ladies, welcome to the fine print. Fereshte, let's first address the moratorium request by the IL&FS's new board. The National Company Law Appellate Tribunal had given this moratorium until the next hearing on November 13th. This was given under Section 242 of the Companies Act that lays down the powers of NCLT. Is it fair for the board to ask for such an extended moratorium, and does the law allow for suspension of creditors' rights for what, 6, 9, 12 months or whenever the final resolution is reached?
So Payaswini, as you know, very interesting situation out there. I think we need to possibly just evaluate what's going on in the context of the law as it stands, and obviously in terms of, on the other hand, the pragmatic reality. Addressing first the law as it stands, which is really actually an extremely interesting area given what's going on out there in terms of what can be achieved in the pragmatic real-time world out there. We must understand that the step that has been taken in this matter is unprecedented. We do not have a legislative framework that addresses what it is that is going on here, and what is clearly being done in terms of the triggering of the NCLT process, to my mind, has no valid sanction legislatively. Okay. Notwithstanding the fact that there has been the Companies Act provisions that have been triggered, we today have an insolvency and bankruptcy legislation in India, and that legislation seeks to address the forms of bankruptcy actions that are capable of being initiated, and clearly the form of reorganization as a route to stave off bankruptcy is certainly not within the legislative remit as it currently stands. And given that there is that, to my mind, seeming lacunae, let's now turn to what one would talk about pragmatic reality and what that warrants. The fact is that we have a systemically important NBFC, a CIC, a core investment company, effectively regulated by the Reserve Bank of India, that is today effectively teetering on the verge of bankruptcy. And the question is, given the exposure that you just laid out, what is it that can be the possible solutions? Do we just allow it to go under, or do we adopt the pragmatic measures that are in fact underway via the NCLT, via the NCLAT, and more importantly, the manner in which they have superseded the board and gone about all that they are doing is clearly, to my mind, in tandem with what the situation requires addressing, no doubt, as I started out earlier by saying, notwithstanding the lack of a legislative sanction. And that, to my mind, throws up a series of conundrums. The first amongst which is what happens to what, for all intents and purposes, is collapsing virtually the entire behemoth of some 347 or 357 odd entities that are sitting out there into one effective group entity, which is what the NCLT and CLAT have done, in order to try and find perhaps potentially and hopefully a long-lasting solution.
So Payasini, I will agree with Fereshte to the point that this is unprecedented. But where I would disagree is that there is no legislative mechanism available. I think Section 242 of the Companies Act does allow for if there is a case of mismanagement and it's in the public interest for courts to intervene and give interim measures of the kind that they've provided here. So there might not be precedence of it. However, a plain reading of the law does allow for it, and as Fereshte mentioned, I guess the pragmatic reality is that this is systemically important and probably too big to fail, and the intervention was really required just given where the markets were. So I think that with the combined provision on the Companies Act reading, I think I wouldn't say that there is no legislative mandate available. However, you've got to then again think about the rights of creditors and how this plays along with the insolvency and the bankruptcy code. Because again, the IBC has a non-abstance clause which says that notwithstanding anything else, any other laws will be superseded by the IBC. So tomorrow, the creditors can question any proceedings going on under the Companies Act under that specific provisions, and we will have to see how, and again, it's the same courts, it's the NCLT and then NCLAT, which will have to look into those provisions.
So is that your view that then Section 242 in public interest does allow the tribunal to extend this moratorium till a final resolution is reached by the board?
I think it's possible to read into that particular provision.
Okay, all right. Pratibha, Fereshte just touched upon this very briefly. It's not just the domestic creditors that are being asked to be patient. This moratorium is going to impact even foreign creditors as well. For instance, back in 2014, IL&FS had, or rather it's one of its subsidiaries had raised dim sum bonds, and as recent as January this year, ITNL Offshore raised money through this route. How do you see this moratorium impact these bondholders? Both of these subsidiaries, IL&FS Transportation Networks as well as IL&FS Offshore, issued these dim sum bonds, and one of the lawyers I was speaking with said that again some of these IL&FS Transportation had given guarantees, and for some of them there were keep well commitments to the investors. Could you take us through the nature of the agreements, and also what sort of remedies may have been incorporated in these agreements in case of a default?
So the offshore, these are all offshore instruments with dispute resolution mechanisms available offshore and assets also available offshore. My understanding is that the assets that these are based under for the offshore subsidiaries issuances in foreign denomination are based on certain projects outside India. So actually the foreign creditors will have access to assets offshore. The only issue that comes into question is enforcing the guarantee of likes of ITNL and other group companies of ILFS. So that's really secondary to the primary enforcement mechanism available offshore, to which this moratorium will not necessarily apply, because whatever recourse they have to offshore assets, they have to offshore assets. When it comes to your guarantees of ITNL, for example, they will have to come to India, whatever award they might get offshore with respect to those particular guarantees, they will have to come to India to enforce it. and at that point they will again have to join whatever process is available in India to them at that point, whether it is the 242 moratorium still being applicable, or there is an IBC process going on. Either cases they become an unsecured creditor and they will have to join the process.
Okay, Fereshte, how are you looking at this? Will some of these bondholders and bond trustees will also eventually hit the moratorium that currently exists under 242?
Well, so I do think that there is a significant scope for challenge out there, because technically I am of the view that the moratorium that has been contemplated and is for all intents and purposes in operation is certainly something that can only apply to the Indian entity, as it were, because clearly we do have a concept in law called corporate separateness, or an independent juridical entity concept, as it were. And given that there is certainly a requirement to ensure that that is not militated against, to the extent that we have actions that will be taken for purposes of recovery or otherwise enforceability in relation to whatsoever the interests might be insofar as concerns the offshore entities, that is obviously on the one hand. But to the extent that they are going to have to look at invoking guarantees, very clearly that is where they will effectively falter on account of the moratorium that is currently in place. And I suspect that if there are parties who are going to have to enforce those guarantees, then very clearly you are going to have a situation on your hands where the moratorium is potentially going to come into some form of challenge. Because clearly if there are judgment holders and award holders, and obviously there's no doubt about the fact that on the one hand you have a remedy, but you have no right. It's your right that is being eviscerated for all intents and purposes by bringing about this moratorium in a mechanism that simply does not exist. It could very well be argued by an offshore party that, look, you have a legislative mechanism which is the IBC, as I mentioned previously. That IBC process is something that must necessarily be effectively brought against the entity in question. You do not have a concept in law anywhere across the globe where you can simpliciter bring this umbrella that will effectively cover the entire group in the manner in which we are doing here. Because clearly, in the absence of a legislative mandate, how do you achieve something like that? And how do you eviscerate rights, and how do you explain to all of those offshore creditors as to what it is that you're offering them? So I do think that there is significant scope for challenge. In my estimation, if a challenge were to be brought, I would expect that that challenge will hold good, unless there were to be some very quick measures brought legislatively in order to address the current situation.
What could some of those legislative steps be, as you've pointed out, might be required?
All right. So the first issue that needs to be resolved legislatively is with regard to whether or not India has in fact a mechanism by which it can effectively permit for what is called a reorganization bankruptcy at a parent level, which would effectively therefore confer that protection upon all subsidiaries within that group. And Pratibha, please correct me if I'm wrong. I do not believe that is a mechanism that is sitting out there in 241, 242, which is what has been invoked.
Okay, Pratibha.
So there's no doubt about the fact that, as I mentioned previously, there is that pragmatic requirement.
Sure. Pratibha, you want to comment on
but there is a legislative lacune. That's the point.
Okay, okay. So there is pragmatic requirement and legislative lacune. Pratibha, do you want to quickly comment on whether or not this new legislative step is imperative at this stage?
Sure. So in terms of the legislative lacune that Fereshte is talking about, that can be easily addressed by making all these subsidiaries parties. Again, like I said, if the 242, I think language is broad enough, and the court in question, whether you find a resolution through the IBC process or through the Companies Act, it's the same court. You're going to NCLT and NCLAT. As far as the foreign creditors are concerned, I don't think they have an effective remedy anyhow, because they have to come to India for enforcement, and at that point they will become unsecured creditors. There are not enough assets to go around, so if they are going to rely on the guarantee of ITNL, they'll be standing with other unsecured creditors. So whether they come under the Companies Act moratorium or they come under an IBC moratorium, which will be put in place if these guys come for enforcement, the secured creditors are not going to keep quiet. So I think, if you ask me, effectively the foreign creditors for enforcing the guarantee at this stage where there's not enough assets to go around don't really have an effective remedy. They will have to either rely on the assets offshore that they have access to, or get in line with everybody else in India.
Okay, that is not really a very optimistic picture for them. The IBC, interplay doesn't just stop at that, Fereshte. There are insolvency.
I want to respond to that.
Yes, please.
Pratibha mentions that it would in fact be available to get over the legislative lacunae by the simple act of joinder of the subs, the subsidiary companies. In my submission, it is not quite so simple, because what you are then doing is you are cherry picking. Because what you are doing really is you're saying, let's look at those which do not have any kind of debt, and let's look at those that do. And I must say to you that in my understanding of what I have understood of the report, clearly there are entities that may not carry the kind of debt that we're talking about. The moment you therefore go in the direction of starting to effectively bring some sort of mechanism by which you bifurcate and you start to divide down the line those which are perhaps potentially solvent and those which are not. And I believe there will be good assets out there, and I believe therefore that you would certainly be in a position to effectively perhaps insulate those good assets by ensuring that they do not necessarily sit within this umbrella protection. Now then the question that arises is, so are you then saying that the order as it currently operates for the group as a whole no longer need operate, because now let's start picking up those subs which are in difficulty and those that are not? That by itself will effectively completely blow the lid off the order that it currently stands as. Because you will then have a situation on your hands which will, to my mind, become entirely unwieldy, because you will have those entities which will then continue to enjoy the benefits of the existing framework of court orders, and then you will have those that will perhaps potentially have to be kept outside of that. And that is why I believe that clearly there is a difficulty in terms of implementation in the absence of ensuring that there is an automatic protection that must necessarily apply, because it could very well be argued by the offshore creditor that when I have an exposure with an entity in India which is perfectly solvent, notwithstanding the fact that it is part of the group, why is it that I do not have remedy and recourse which I should very well be entitled to, but am effectively not in a position to enforce my legal rights on account of an order operating at what is, for all intents and purposes, almost a global level?
Sure, okay.
And I say global level because clearly you're talking A, about parent company, and B, you're talking about offshore entities.
Sure, okay. Pratibha, you wanted to add something?
Yeah, not to make this a courtroom, but
it's turning out to be
I don't
one.
think we're talking about cherry picking, right? Let's see what's. I think it comes with the profession, but I don't think we're talking about cherry picking. If you look at what the courts have already done and what the board is looking to do, the courts is basically giving the board, by giving the moratorium, a time to figure out if there is a possibility outside of the IBC process to salvage the existing business, and to put some of the affairs in order. Now, Like I've said before, I think you know, the NCLT and NCLAT will have to figure out whether they are comfortable doing this process outside the IBC, or you know, it would necessarily have to be something as provided under you know, the IBC superseding the Companies Act provisions, for example. That's when the difficult question will come up, and that's why I said this question needs to be examined, whether the courts will let the directors have a free hand in providing a solution that needs to be implemented, because that I agree there is no provision for today in the Companies Act. Then you go into the domain of IBC, where there's a whole process laid down, where the Committee of Creditors is going to run this process rather than the board.
Okay, but that sounds like that it's going to be a mix of...
from the ability, doesn't take away the ability of the court to impose a moratorium.
Okay, all right. Okay, no, like you said, it's going to be a complex process, and now compounded by the fact that there are several insolvency applications that are pending against IL&FS and some of its group entities. For instance, IL&FS Financial Services and a thermal power unit in Tamil Nadu. Fereshte, I imagine that these will also be part of the final resolution plan that the board comes up with. So what do you do now? Do you withdraw these insolvency applications and bring these entities out of the purview of IBC, because there's a process for that as well? How will this work?
So that is precisely where the dilemma lies, Payaswini. I think you've put your finger on it. The fact is that you have a legislative framework which essentially contemplates insolvency and obviously the processes that must follow an application, and obviously if you can manage to stave off liquidation, that is precisely what the process is actually geared for. And then you have your 241, 242, your reorganization as it were, which is what is currently in contemplation. And very clearly, we do not have any sense of what is going to happen with those insolvency matters, for the reason that technically the moratorium must necessarily catch within its snare everything that is sitting in any form of legal proceedings. So the question then is that what you have here is a situation where, without really getting into the granular beyond the point in terms of the legislative mismatch, if you will, you have a situation where the existing insolvency remedies are effectively being taken away from those creditors who have properly exercised their rights in law in favor of what is, for all intents and purposes, a wider process that is going on. And unless we actually grapple with these issues and find, as I said previously, but of course there may be practical solutions, Dehore's legal solutions, I do believe that if we were to legislate, we will be able to perhaps put into place a framework that will permit for this process to go on uninterfered by courts to a large extent, in terms of contesting by creditors with regard to the lack of legislative mandate and the like, because typically what I am saying is what I'm reasonably certain a lot of other lawyers are advising their offshore clients, which is that, look, there is clearly something to be questioned here, and that question could very well delay and disrupt and derail what is obviously the intention of the NCLT and CLAT when they have passed the orders that they have. To answer your question, I do believe that the IBC process is, for all intents and purposes, kept on hold on account of the moratorium that has come in. We do not have any sense of how long that moratorium can get rolled over for at this point in time. And very clearly, if there is no certainty, you are going to have a lot of creditors who are going to start losing patience.
Okay, I will take your point on creditors' patience to Pratibha. Pratibha, the insolvency, process has a COC which is mandated to decide who gets how much, and the plan is then approved by the NCLT. How will this negotiation work in IL&FS case, where all this is happening under the Companies Act? Does the board now sit across, the creditors and individually negotiate with them? And if they don't do that and decide who gets how much, can the aggrieved creditors challenge this restructuring or haircut on their debt once the moratorium is over?
Of course, the creditors' right are well enshrined in the IBC. And in fact, just on your previous question, there is a precedence actually, notwithstanding Section 238, which gives IBC the supersession powers over any other act, including the Companies Act. I think it was Jyoti Industries, where the court said that where there is an action that is in favor of the company as a whole, the moratorium can be ignored for the purposes of allowing the company to go ahead and act on a particular court proceedings currently going on, as long as it's for the benefit of the company. So the courts have seen this situation before and allowed for IBC process to be superseded by, in that case it was an enforcement action under Section 34 of the Arbitration Act. Given the circumstances today, the creditors also recognize that if they go through an IBC process, the unsecured creditors are probably not getting anything if they're standing in line. So the whole idea is to see if they can, sell these companies or find a reorganization plan which provides a much better value than under IBC, and hope that all these creditors then are happy with the resolution, which is a huge uphill task. I mean, it's easier said than done. We've seen enough of other, I've seen some infrastructure holdcos which have tried to stave off an insolvency process, and it's extremely difficult because even if one creditor goes, it derails the whole process.
Okay, all right. Well, the board has sort of warned the creditors by saying that, high leverage, poor returns and asset liability mismatch is expected to entail sacrifices from various stakeholders. So clearly they have a tall order to ensure that the creditors stay patient, and it will be even more challenging, like both of you pointed out, to ensure that IL&FS or its group entities don't face a litigation whirlwind once this moratorium subsides. Thank you, Fereshte and Pratibha, for sharing your thoughts on how the IL&FS's new board can achieve some of this. And before you go, the fine print has just turned 1 this month. A big thank you to all of you who have participated, watched and read our coverage. Keep watching and do share your feedback. We'll see you next week.